Hello everyone, welcome to the course that is Understanding Competition Law Theory and Practices. Myself Dr. Mayank Pratap, Assistant Professor Faculty of Law from Banaras Hindu University, and we are dealing with the course Understanding Competition Law Theory and Practice from last 3 lectures. So begin with the session. You are welcome to this session. Today we will take up the lecture number 5, that is Indian Constitution and Competition Law. The objectives of this lecture is to understand the constitutional aspect of competition law and to discuss the constitutional values related to the constitutional law in this lecture. So to begin with this particular lecture of today, have a snap with a previous lecture, that is in third lecture what we have discussed. Basically in last lecture what we have discussed what is the nature of competition law. The nature of competition law is basically multifaceted, unique and complex. In last lecture, we have dealt with the competition law is basically the primarily a public law having the economic law aspect, that is because it is called like the branch of economic law, but the basic attribute of this act is it is a regulatory law which has some regulatory framework to regulate the competition in the market, which deal with fair competition and which deal with the prohibition of anti-competitive practices for regulate the merger and any combination or combination relation and prohibition of dominance of abuse of dominant position. So with this in last lecture we have discussed the output. What we find that there are more than 125, particularly 129 countries are there who are globally practicing the competition law as antitrust law, and particularly the Competition Act 2002 is of the nature of hybrid in competition law. Why this is a nature of hybrid nature? As we have discussed in last lecture, competition law actually tries to balance between social goal such as protecting consumer welfare with economic goal and promoting economic efficiency, and on other hand it is like the evolutionary nature, having the evolutionary nature. Evolutionary nature means it is a subject which is not static. It evolves in response to change in the market, economy and society. So in conclusion, what we found that competition law as per its nature, it is a hybrid of social and economic law, balancing goals such as protecting consumer welfare and promoting economic efficiency. It is a law primarily which falls within the meaning of public law, but having the attributes of civil law, criminal law, social law and economic law. That's why we are saying it is a multifaceted, complex and unique law as per the objective and ingredient of Competition Act 2002. So let's start with the today's lecture. Here we will start with the preamble of the Constitution, because the preamble of the Constitution bears all the attribute which reflect through in a Constitution. By Constitution's preamble, we can find out what are the main ingredient or the philosophy of the Constitution. So if you see the preamble of the Constitution, particularly the Indian Constitution, sets out the guiding principle and objective of the Constitution. And the 42nd Amendment, which was enacted in 1976, introduced the significant changes in the preamble, which incorporates the economic values and reflect the socialist and egalitarian ideals in the Indian state. Particularly if you see some points of 1976 amendment, that is known as 42nd Amendment or the mini constitutional amendment, which was enacted in 1976, introduced significant changes to the preamble incorporating new economic values. And what are the economic values? If you see, we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens. That means there are particularly two terms which is related to the economy, that is socialism. And start with the socialism. If you see, the amendment incorporated the term socialist into the preamble, which reflect the Indian state's commitment to socialist ideal and the redistribution of wealth. That means socialist is not only a term, but it is a philosophy. Why it is philosophy? Because it actually deals with a school, and a school of decentralization of wealth, a school of redistribution of wealth, a school of India's commitment to its ideal, its guiding principle and philosophy in perfect relation with the economic values. So, what is the implication? What are the implications which spurs the or which have pushes or impact on competition law or growing competition law at that time? Actually, the 42nd Amendment had significant implication on Indian economic policies. Indian economic policies, what has changed they got after the 42nd Amendment, that the policy has shifted towards socialism. The amendment marked a shift towards socialism, with the Indian state increasingly the intervening in the economy to redistribute wealth and promote social welfare. It increased state control. The amendment, that is 42nd Amendment, the inclusion of the word socialist, which lead to the increased state control over the economy, with the government playing a more active role in regulating industry and allocating resources. And the impact on economic development. The 42nd Amendment's emphasis on socialism and state control has had lasting impact on India's economic development, with some arguing that it has hindered economic growth and other arguing it has promoted social welfare and equality. So, 42nd Amendment introduced a significant change in economic values, including socialism and secularism. These values have had a lasting impact on India's economic policy and development, shaping the country's approach to economic growth, social welfare and equality. So, if you see what are the impact or what are the changes which has brought by the 42nd Amendment, that the 42nd Amendment provided a guide, provided a guideline, provided a pathway, provided a light which enlightened the Indian economic policy or approach to Indian economic policy towards that means the particular government of that time, that we have to shift our policy toward this socialism. We have to shift our philosophy towards socialism. We have to shift our economic policy towards where there is no centralization, rather there must be decentralization or redistribution of wealth or assets. So, the term socialist implies the social and economic qualities among the people. Social quality in the context means the absence of discrimination on the ground only of caste, color, creed, religion and language. Under social equality, everyone has equal status and opportunity. Economic equality in this context means that the government endeavor to make the distribution of wealth more equal and provide a decent standard of living for all. If you see some judicial pronouncement, particularly at the time of in 80s, where the philosophy was, economic philosophy was in changing mode, the case of in D.S. Nakara versus Union of India of 1983, where the Supreme Court observed that the principal objective of socialist state is to wipe out the equality in economic conditions, status and standard of life, and in a democratic welfare economy, the role of state is never out of season and reason. Our constitution directs the state to ensure a planned and coordinated social advance in the field while preventing concentration of wealth and power in few hands. The socialist model of development is well reflected in the directive principle of state policy, which direct the state to perform its obligation in order to achieve economic and social justice. So, if you see the inclusion or insertion of the two particular word, that is socialist and socialist, basically particular socialist, if you see, it is a word which directed our competition policies, which has changed our vision from where we have shifted to socialist approach in our economic policy. And this is basically not a philosophy just from shifting to the concentrated wealth to redistribution of wealth, that is related to the constitutional element what is under Article 38 and 39. Only the socialist word is not responsible. Socialist is a word which actually reflect our vision from where we are going to in our vision, not in only the economic sense, but in a social regime or our balancing element or in our direction, vision and in our approach, that is approach of government towards society or society towards the democracy. Constitutional aspect, if you see, that is for particularly Article 38 and 39, which is regarding elimination of the concentration of wealth and distribution of resources. Article 38 and Article 39, the Constitution of India mandate inter alia that states shall strive to promote the welfare of people by securing and protecting as effectively. See, 38 and 39, what they mandate, basically it is a line or phrase which reflect the element of competition. If you see with focus on the term state shall strive. State shall strive, that means state, it is the not only the responsibility, but state shall try its best effort, like what a competitor tries to achieve, how a competitor struggle to survive. In that manner, state shall strive to promote the welfare of people by securing and protecting as effectively as it may a social order in which social justice, economic and political shall inform all the institutions and national life, and the state shall in particular direct its policy towards securing what? Securing the ownership and control of material resources of a community are so distributed as best to subserve the common goods. That is Article 39. The clause B of Article 39 strive and ensure, which state as the ownership and control of material resources of community are so distributed as best to subserve the common goods. And again, that the operation of economic system does not result in the concentration of wealth and means of production to the common detriment. That is Article 39 clause C. What is Article 39 clause C? It focuses on economic system may not be result in concentration of wealth, and Article 39B focuses on community, for that means the material resources must be distributed so it is be used as subserve the common good. So if you take the Article 39B and Article 39C in toto, it reflect that aim of moving India towards a welfare state. That's why what we are discussing here, after 42nd amendment, we have shifted our policy towards socialism, where the approach of government has focuses to the society towards the welfare of society and welfare of a state rather than laissez-faire state, and building a just and equitable society, and mandate that state shall in particular direct its policy towards securing what, that is ownership and control are so distributed to best subserve the common good, and that the operation of economic system does not result in concentration of wealth, means of production of common detriment. Means the Constitution of India postulate the monopolies created by an inequitable distribution of resources and their concentration in the hand of the few are inimical to democracy. Consequently, Article 39B of the Constitution should be construed in the light of Article 38A of the Constitution and be understood as placing an affirmative obligation upon the state to ensure that distribution of material resources of the community does not result in highlighting of inequality amongst people and among regions. So, from the above discussion, it becomes clear that Constitution of India mandate the state to direct its policy towards securing that the ownership and control of material resources of community are so distributed as to best subserve the common goods, and that the operation of economic system does not result in concentration of wealth and means of production to common detriment. Thus, state intervention is necessary to some context India to eliminate concentration of wealth and to effect distribution of resources in equitable manner. So, if you see what are the linkage between the constitutional perspective or constitutional value and with the competition law, you will be find that constitution have some values like constitutional values which reflect in the constitution preamble itself, and DPSP, Directive Principle of State Policy, and the vision of the constitution is the approach is very clear. There must not be centralization of wealth. There must be redistribution of wealth in such manner which can be used for common good, for common goal. And with this approach, what we are considering as a socialist approach was the primary issue or primary focus of that time, that means the first government. So that if we see what are the linkage between constitutional principle and constitutional values with competition law, we can say there are some element under the constitution like socialism, secularism, justice, which is social justice, economic justice, are the values which promotes our vision towards and which reflect in economic policies. And at that time, that means after getting independent, at first the formation of government which start with Nehruism or Nehruism era, and after that in 1960 and later on when the 42nd Amendment has came into the picture, our policy shifted from licensing regime to promotion of competition, not actually promotion of competition that time, but yes, to regulation of or monopoly practices. So, if you see the prime antitrust law, which was MRTP Act, which is started, but we will discuss it later. What we are discussing here only the constitutional aspect. So, we can say from the above discussion that after independence, the Indian government assumed a greater role for overall development of the country by laying down the policies which aimed at achieving a socialist pattern of society which promotes equitable distribution of wealth and economic power. However, the ghost of British had influenced on the policy framework on the government, and thus the system of control restricted freedom of entry into industry, which led to the concentration of economic power in the hands of a few individuals and business groups. And after this, government appointed a monopoly inquiry committee in 1964 to investigate the extent and effect of concentration of power in the private sector and to suggest necessary legislative or other measures in the light of findings. So, the commission, the MIC commission in its report held that there was concentration of economic power in the hand of few industrialists and they indulge in monopolistic and restrictive trade practices. So, to review and to protect the rights and to treat the monopolies or restrictive trade practices, to prohibit these type of the static practices and monopolistic approach, the Monopolistic and Restrictive Trade Practices Bill in 1969 to check the concentration of economic power, control the growth of monopoly and prevent various trade practices detrimental to public interest. 1969, India's first competition law came into force in June 1st, 1970. So, with this, what we can conclude here, that what are the constitutional aspect or constitutional perspective of the competition law? Competition law actually for the purpose to promote competition, in fact they promote fair and just competition, to curb the monopoly, to curb the anti-competitive practices, and with the philosophy, what philosophy embodied in our competition policy, because competition policy, which is a greater and wide term, under which or with this objective or under which the with the method to execute that policy, the competition law work. So, the key point is what is our policy, so that on the basis of our policy, our law has to be act. So, the basic fact is our policy was pushed by the constitutional values, and the values which was basically embodied or constituted in Article 38 and Article 39, and the constitutional values which is under the preamble of the Constitution, like socialist approach, sovereign approach, social and economic justice. So, we can say the constitutional values embodied in preamble of the Constitution, like socialist approach, sovereignty, just and social and economic justice, are the main attribute on which our philosophy had getting shaped, and our philosophy puts our the policy of the government, and which reflect in government's policy towards the economic policy, so that our competition policy came into shape, embodied or wrapped in the principle of constitutional morality and constitutional values, and that the values is which were embodied in that policy was executed by the law, and the tool which has been used is the competition law, and the competition law, particularly competition law after 2002, and but before competition law, antitrust law, which was the MRTP Act, was the tool to execute the competition policy which embodied the constitutional value. So, both are interrelated. That means constitutional law have the value which reflect in our policy and in our competition law. So, with this we will end up this session here, and in next session we will discuss the origin, growth and development of competition law in India. So, with this, thank you in this session.